Good afternoon, everybody. Today is the second session out of the three-part mediation sessions that Young AFSA will be hosting. We're very happy that you've been able to take the time out to join us today. Just as a quick recap, in case you may have not been able to be a participant at last week's session, but we had Advocate Duncan Turner, SC, take us through, in essence, Mediation 101, which is very helpful. And following this session, which we'll have with Advocate Chris Loxton, who I will introduce shortly, we will have a further session next week on the 2nd of September. So we hope that you can also join us for these interesting sessions at that point. And please do remember, if you have any questions to ask, please feel free to do so. During the talk, we'll have different segments at which we stop and address each of the questions that may arise. But perhaps let me get right to it. So what Young AFSA is trying to do with these seminars, as well as many others that will be forthcoming in the near future, is obviously create an environment, a space where our membership can attend these sessions, can look at them back after them, as they will be recorded and uploaded to our website, and obviously gain training from not just amongst ourselves, but by way of the likes of very senior advocates in the field, as well as attorneys. Last week, Duncan Turner SC was happy to assist us in, training us up insofar as that process. And Advocate Chris Loxton, SC of Group 1, is here to do that in the particular topic and frame of mediation and how that works and operates, and more so how that looks like in the mining space as well as the construction space. Two of, let's call it three expertise that Chris has. The third, I would definitely say, is the field of insurance. So Advocate Chris Loxton SC was called to the bar in 1978 and has been an integral member of the bar, having set up what ultimately has become Group 1, which is one of the bar's largest groups. Advocate Chris Loxton had silk conferred to him in 1992, and as mentioned, he is a specialist and a pretty big heavy hitter, if I say so myself, in the fields of mining, insurance, and other regulated industries. Chris has, of course, appeared in the High Courts, the Supreme Courts of Appeal, as well as the Constitutional Courts, in both mining, construction, and insurance-related matters. But to mention a few that you can go onto the Group 1 website and take a look at these seminal judgments. But by way of example, Johannesburg City Council versus Television and Electrical, 97, as well as AFSA versus Standard Bank in 1998 in the SCA, and more recently, Minister of Mineral Resources and Others versus Sishen, 2014, which was in the Constitutional Court. Advocate Chris Loxton will be focusing, as mentioned, his talks around mining and how mining can be, well, mediation perhaps can be improved in the mining space. And thereafter, we will be moving to discuss construction. So I think this is an apt point to now hand over to Chris. Thank you again, Chris, for kindly volunteering your time to attend the session and assist in training us up. Of course, I certainly will be learning from this as well. So over to you, Chris.
My pleasure. Thank you very much, Nelly. And good afternoon, everybody. This, as Nelly has said to you, we are going to divide this into two parts. The first part will be mining, and the second part will be construction. And it's probably better that the questions that you have, if any, will follow the end of that particular section of the talk. So starting with mining, it's necessary to start with why it is that AFSA has become so preeminent in arbitration. And that is because decades ago, Michael Cooper in particular, AFSA in general, approached all the major financial and corporate institutions to persuade them to include an arbitration clause in their agreements, in terms of which, instead of disputes going to the High Court, they would go to arbitration to an AFSA panel. Now, that meant that when the parties had a dispute in those cases where AFSA had been included as part of the dispute resolution clause, that was a step they had to take. So I'll give you an example of how that works, and to show you the difference between mediation and arbitration, that in that environment, mediation is still the poor cousin of arbitration, because you will not find the obligatory reference to mediation in those contracts yet in respect of AFSA. So I'll give you an example. I think probably Eskom has more disputes than any major corporation in the mining sphere. They have coal supply agreements with at least 20 or 30 coal suppliers, and their disputes are regulated in a particular way. But I'm going to take you through the steps that a typical coal supply agreement requires a party that wishes to raise a dispute to go through, because it will give you an indication of the relationship between arbitration on the one hand, which is well entrenched, and mediation on the other, which is relatively new and not well entrenched. So in this contract, there are a number of steps. Step one is just giving notice of the dispute. Step two is, if the notice is not complied with, then the dispute must be formulated. Then what happens is that they attempt to get resolution, and that resolution is by way of a meeting, and so that's effectively mediation. Then if they don't resolve the dispute through mediation, then what they do is that they go to arbitration. And you'll find that it's not called mediation in those contracts, it's just called an attempt to reach a resolution, and AFSA is not named in the contract. And the same goes for all the other major corporate contracts that I've seen. I've looked at Eskom, I've looked at Sasol, I've looked at a number of them who you would expect which would have a number of disputes to resolve. There are two, so in the contractual sphere, and I'll come to construction in due course, which is a contractual area. In the contractual sphere, AFSA has not yet penetrated those generic contracts to the extent to which they have in the field of arbitration. Now, moving to the field of mining, you're now not dealing fundamentally with contractual environments. Disputes are seldom between one mining right holder and another. And even when they are in a statutory space. In other words, those disputes are dealt with in terms of the MPRDA, which is the act which regulates mining in this country, and also gas production and exploration. When you get into that sphere, what you find is that you've got one area where there is, in fact, a requirement that the parties attempt to settle disputes. And that is Section 54 of the MPRDA. And that section really deals with disputes between landowners and holders of mining or prospecting rights, where the landowner won't allow the holder of the right to enter the land. And in that case, the holder of the owner or legal occupier of the land says you can't come on, and then the holder of the mining right or prospecting right must notify the regional manager. And then this is what section 54.3 says. If the regional manager, after having considered the issues raised by the holder under subsection 1 and any written representations by the owner or the lawful occupier of the land, concludes that the owner or occupier has suffered or is likely to suffer loss or damage as a result of reconnaissance, prospecting, or mining operations, he or she must request the parties concerned to endeavor to reach an agreement on the payment of compensation for such loss or damage. In other words, this is another word for mediation. The Act requires a degree of mediation, but the regional manager plays very little role in that. The only role he plays is that if he thinks that the failure of the parties to reach mediation is as a result of the fault of the holder of the right, he can order that costs be paid by the holder. And then it goes on in 54.4. If the parties fail to reach an agreement, compensation must be determined by arbitration in accordance with the Arbitration Act. Now, that means that there is a statutory framework in place which effectively excludes AFSA. And AFSA is excluded because there is a peremptory legislative process in place. So in the mining sphere, AFSA's role is limited ultimately to disputes between holders of mining rights or prospecting rights, which is not generally the case. And even where there is a dispute between them, it's a dispute which must be regulated through the statute itself. So in the sphere of mining, unless you can persuade the MPRDA, rather the DMR, the Department of Mineral and Energy, to agree to a mediation, and I'm not sure they even have that capacity, you will be excluded as a mediator. So there's not really an opportunity there. There's a similar framework in the income tax sphere. So if you have a look at the Tax Administration Act, you will see there that in Part F, at Section 142, there is, and following, there is a provision for settlement of disputes, ADR, and it sets out, and it says, it defines dispute very widely, and it says to settle means to resolve a dispute by compromising a disputed liability otherwise than by either SARS or the person concerned accepting the other person's interpretation of the fact of the law applicable to those facts, or of both facts in the law, and settlement must be construed accordingly. And then it says, the basic principle in tax law is that it is the duty of SARS to assess and collect tax in accordance with the laws enacted by Parliament, and not to forgo a tax which is properly chargeable and payable. Circumstances may require that the strictness and rigidity of this basic principle be tempered if such flexibility is to the best advantage of the state. The purpose of this part is to prescribe circumstances in which it is appropriate for SARS to temper the basic principle and settle the dispute. Now, there at least, there is no prohibition on mediation by a third party, and there is space for mediation by a third party, unlike the MPRDA, where there is no statutory space for that really. It's all regulated by the Act itself. So comparing the two statutory frameworks, where there's a statutory provision for mediation, at least in the case of the Tax Administration Act, there is space for the taxpayer to say to SARS, we wish to employ ADR and we wish to employ the services of a competent mediator. And so in that space, it is possible for AFSA, and it is possible for members of AFSA who wish to specialize in mediation, to at least speak to attorneys who specialize in tax and the resolution of tax disputes, to approach SARS in cases where ADR is competent, to employ the services of members of AFSA in that field. So in summary, in the mining field, there is limited space for mediation through AFSA. The only way in there is to approach the mining houses, Anglo-American, Billiton, and the rest of them, to incorporate those provisions in the case of disputes between holders of mining rights, which does not require to be settled or resolved through the provisions of the MPRDA. And those would include, for example, disputes about encroachment of one mining right over another, disputes where the Director General or the Minister has awarded conflicting mining rights over the same mineral, for example, or the same seam in respect of platinum group metals, or over the same land. And so the regional manager would probably welcome and encourage parties to resolve their, and always does encourage parties to resolve their disputes by mediation. But you will only achieve that if you can persuade the large mining companies to incorporate that as a standard provision in their agreement, so that where they have a dispute between them, mediation then becomes obligatory before there's an approach through the MPRDA itself. And of course, you can encourage those substantial mining right holders to suggest mediation where the dispute is with a junior miner. So that really is the position in respect of mining, also in respect of tax. And as I've said, there are two aspects to this. The one is that there is not a significant penetration at the moment in respect of AFSA mediation in the standard agreements with mining companies. And there's a problem of the statutory framework. There is one other area in the mining field which is not directly concerned with disputes between mining houses and the Department of Mineral Resources and Energy, and that is in the field of disputes between holders of mining rights and parties who are the beneficiaries of social and labor plans. So, for example, every applicant for a mining right must have a social and labor plan. That social and labor plan includes commitments to mine-affected communities. So those communities surrounding the mine, it will require, for example, that there is a particular benefit in terms of employment, in terms of the provision of schools, water, electricity, and the like. And there are frequently disputes between members of those mining-affected communities and the holder of the mining right as to whether or not the provision or the obligations under the labor and social plan have been given effect to. And they then either land up in court or they go by way of a complaint to the regional manager, and then the regional manager says to the holder of the right, you have not complied with your social and labor plan, which is an integral part of your mining right, and we want compliance, which takes forever and it's very complicated. So there is, again, in that field, there's simply a lack of penetration of a standard AFSA clause for either arbitration or mediation in disputes between mining affected communities and mining right holders. And it is an area where there is significant scope for mediation work for members of AFSA in that field, because those disputes are frequent, they go on for years, and they are fairly complicated. And they are driven by all sorts of other factors which are difficult to unravel, such as political issues, perhaps mistaken expectations about the economic benefits and the like. So that, broadly speaking, is the mining sphere. There is limited opportunity in direct conflicts between the mining right holders and the department, and between mining right holders in respective matters which must go through the MPRDA. But there is scope for a suggestion to mining right holders that they actually engage in mediation through AFSA where there's a dispute between the landholder and the mining right holder. Because these are not contractual relationships, it is difficult to overcome that problem by simply introducing a contractual provision. And there it's more a question of approaching the holders of the major mining companies and saying, where you have these disputes, will you suggest mediation through AFSA? And I'm sure that they'll be happy to do that. And then again, to repeat, in the disputes between mining affected communities and holders of mining right, there is scope. Again, the only way to introduce mediation is to persuade the holders of the mining rights to suggest mediation. And I would imagine that of all the in all the fields of economy in this country, mining is probably an area where there are more disputes which are capable of being resolved by mediation than in any other field. It's just a question of persuading the Anglos of this world and other major mining companies to either adopt mediation or to suggest mediation. And Neddy, that's really the end of the mining sphere.
All right. Thank you for that, Chris. That was incredibly interesting. I see that there aren't any questions in the chat, but I do, in fact, have a question, and it might be a two-part question. Chris, I'd like to take you back to section 54 of the MRPDA, because that seems quite interesting. It's a section that seems to sort of smell of mediation, but we're not quite there, at least based on what you've explained. And just to recap, my understanding is that the section purports that a holder may bring any machinery or equipment onto the land at the time that they've obviously ascertained the mining rights. But he or she must also try by all means to reach some kind of agreement on the surface use of the prospecting area. And the reason behind, Section 54 being included in the Act was that, landowners mustn't use or mustn't make unreasonable demands. And in circumstances where there actually is going to be damage or loss to the property, this is a mechanism which could be used through implementation by the regional manager. But it seems that the section doesn't go any further than that. It just says There's a regional manager. You have about 14 days. If there is going to be any damage or loss to the property that the community is concerned about, try and resolve this amongst yourselves with the assistance of the regional manager. In saying that the section doesn't go further, do you think that that was intentional by way of, you know, how the section was structured and how the act was structured? Is there a vacuum which exists in the act? Is this an opportunity for, I don't know, guidelines to be developed to sort of outline how it is that the regional manager should, let's call it, mediate these instances? Because what's quite interesting is that, of course, you know, you don't often hear any sort of reported instances of mediation, and it's quite interesting to hear how that perhaps plays out in reality if you've been, and I'm sure you have been, a part of any of those discussions with the regional manager and, you know, the mining houses, etc.
Yes, so you need to take a step back. Section 5 and Section 5A effectively say that a holder of a mining right can go onto the land with his machinery and mine. Section 54 deals with compensation. The argument before the Constitutional Court in Maledu, which is 2019 2SA 1, was that the fact that Section 54 deals with compensation and disputes with compensation doesn't mean that the holder of the mining right can't, in the meantime, go on and mine. And Section 54 doesn't stop you from mining. The Constitutional Court held that that argument was wrong. They said you cannot start mining unless we call them the mediation provisions of Section 54 have been, until they've been completed and exhausted. And so in that particular case, they said that the mining company could not complete it, could not go onto the land and mine because they hadn't actually attempted to exhaust that process. Because their argument was they don't have to before they can mine. Now, there was a later case which interpreted that, and that's Stuart Cole versus regional manager in Mpumalanga. And that is case number 2585/3023. And it was, if I just have a look at this, I don't know if it's reported yet, and it was delivered on the 16th of July, 2024. And what that said is that where mediation is exhausted, you can go onto the land and mine. So it's not something which is permanent. So that's the position at the moment. Now, I've been in situations where the regional manager calls you in, calls the holder of the mining right in, calls the owner or lawful possessor in and says, I want you to settle, or where there's a dispute between different holders, where the one holds the right to platinum, the other one's managed to get himself a right to iron ore, and they can't both mine at the same time on the same land. But those sessions with the regional manager as chairman, there's a provision which deals with those objections, and that's the REMDEC, which is a regional body set up within the department to deal with it. They're hopeless. They have no skills in mediation. They're not particularly au fait with the law, and so they're very seldom, apart from a bit of bullying, get anywhere. So there's a definite need for mediation, but the only way through the door is to persuade mining companies to ask for mediation through a trained mediator when they get into those situations.
All right. And we have two questions in the chat, Chris, and I think let me start off with the second one from Stephen. I think it tailgates right where you left off quite nicely. now having at least looked at, you know, the provisions of the relevant acts, as well as practically how this tends to play out, and I'm at least happy to hear that there is at least judicial support towards mediation insofar as that judgment that you've just mentioned from earlier this year. What is the realistic appetite for mediation in the mining sphere? And that's a question from Stephen Dodge. And I mean, I would add to that, you know, having had the MPRDA framework up for quite some time, and having obviously gone through various disputes over the years, it seems that we still, let me call it, still have this vacuum which exists. Is that indicative of the mining houses and their attitude towards mediation? Is that just a gap that hasn't been filled yet? You know, if we did have well, if we do have a Michael Cooper, if he were to approach these mining houses, how would that play out? What is your sense, at least from having represented many mining houses?
I think it would, you know, I think they just don't know they need specialist mediators. They don't know. You know, it's like that thing is, there are things that you know, there are things that you don't know, you know, that you don't know, and there are things you don't know, you don't know. So that's, they don't know that they don't know that they need mediation. I think that if there was an approach, if there were an approach, they would welcome it, because mediation directly or discussions directly between the mining house and, let's say, mining affected communities, or disputes which go to the regional manager over in Section 54 disputes, takes up a lot of time, is often not successful because the mining houses simply don't have the skills. And so, and also they are treated with suspicion by mining affected communities and landowners. So I think that if a proposal were put together to mining houses to use professional mediators, trained mediators, I imagine that they would welcome it. They would look at it in terms of a route which they could adopt. It would cost them a bit of money, but it would not involve them in those allegations of, well, of course you're biased and we can't trust you to even negotiate with you. So I think there would be appetite for it.
Interesting. Right. And the second question actually might lead us into your next topic, construction. But Colin has asked, how do you manage the complexity of technical issues in construction and mining disputes when the parties involved have vastly different levels of understanding, I suppose, of the various acts of the law in and of itself? And Colin then goes on to say, what strategies do you recommend for mediators who are not experts in technical aspects of these industries? How can they upskill themselves or improve what it is that they're there to do?
I think there are two answers to that. The first is that the complexities are not as severe as they appear to be. So with a bit of application, you can actually deal with those complexities, because when you think of it, judges have no particular skill in mining or in construction, and yet they're called upon to determine those disputes quite often. Advocates have got no particular skill usually in it. So it's like working up any brief. If you take, let's just take mining, for example. The obvious starting point is to familiarize yourself with the relevant mining legislation, which would be both the MPRDA and the Environmental Acts and Regulations, NEMA, the Water Act, and so on, because they're all related, and a lot of disputes would include that. For example, someone says, your water use license doesn't cover this, and I'm the local farmer, and you're using my water, and you're not allowed to use my water. So those things require homework. You need to first familiarize yourself with the environment, the statutory environment, then take a bit of time off, read the cases. They're all there. And then it's a matter of just living with those matters, persuade the mining companies that they need you. So it's the skill, we put it this way, your skill as a mediator is more important than your knowledge of the particular topic. You can always acquire that. And you will acquire it more and more the more you do. In construction, we'll come to that in a moment, there are particular standard contracts. You have to understand those standard contracts, what they do, and their mediation takes on a different form. And we'll get that to that in a moment. So, for example, there are very few standard contracts which involve mediation. One does, but then you have DAB, which is dispute adjudication panels, boards, and they are not dissimilar to mediation. It's mediation with a bite at the end, because they make a finding, and then you're obliged to, you've got an automatic right to go to arbitration, but you're obliged to implement the finding of the DAB. So it's a sort of hybrid between arbitration and mediation.
That is quite interesting. There are a few more questions, but what I'll do is I'll just relay one more and I'll leave the balance of them to the end. I'm just a little bit conscious of time because I know you have a little bit to say about how it works in construction and with the DAB, but we will circle back to the balance of the questions. So again, we have another question to the effect of, would mediation be more frequently used if a mediator's opinion were, for example, binding upon the parties? And it's quite interesting because we obviously know that that is the case with the DAB, but with the regional manager, and at least insofar as my understanding is, that is just in essence a mediator in its true sense. That's there to get the parties together, get them to communicate, hopefully reach some kind of agreement. But in circumstances where it's not, how impactful or what binding nature, if any, does the regional managers or any subsequently appointed mediators view or opinion, how cast in stone is that?
So in disputes between the department and a mining right holder or a surface right owner, you're not going to get an agreement about a binding mediation. So when we deal with binding mediations, we call them medarbs, where you start with mediation, you end up with arbitration. So that there's the interesting thing about medarbs is that you disclose your position to the mediator, despite the fact that you know that the mediator is ultimately going to make a binding decision. So that's quite that's quite a step. It would work in disputes. Let's take a Section 54 dispute where the parties are now supposed to go to arbitration, but there's nothing to prevent those parties, landowner and the mining right holder, from agreeing that before they go to arbitration under the Arbitration Act, they will follow a mediation process. So that would be by agreement. Where it has probably its most purchase and where it's probably going to be more acceptable to mining companies is in the field of mine-affected communities, because those disputes are frequent, and it's better that it ends up in finality, short of actual formal arbitration. So they are always looking for a way in which those disputes can be dealt with quickly and finally, without too much formality.
Interesting. Okay, thank you for that, Chris. I think it's probably an apt time for us to hand over for you to then take us through mediation in the construction sphere, and then we will circle back to the balance of the questions.
Okay. All right. So what I've said about the AFSA's role in mediation in relation to mining applies equally in respect of their role in the construction sphere, because whereas you've got a very significant presence, AFSA, in arbitration clauses. You don't get that in mediation clauses. Now, we'll deal with the different standard contracts. So if I have a look at NEC, which is a standard engineering and construction contract, what you find there is when there's a dispute, it first gets notified to a dispute adjudication board, and the dispute adjudication board makes a decision ultimately. It's binding, but automatic right of appeal. It must be implemented, even though there's an automatic right of appeal, a court of appeal, but it's just a reference to arbitration. Now, that's the NEC, NEC3. Then FIDIC has got a very similar design. So you go dispute, notification of dispute, response. If no settlement, you go to a DAB, and then you go to arbitration. The standard building contract for JCT is slightly different because they do have an arbitration clause, and this is also a standard building contract. And in clause 9.1, they deal with mediation, but it's very much the poor cousin. So they do mediation, adjudication, arbitration. And all it says is that subject to Article 7, if a dispute or difference arises under this contract, which cannot be resolved by direct negotiations, each party shall give serious consideration to any request by the other to refer the matter to mediation. Then, interestingly, in that area, you'll find that the International Chamber of Commerce also has an arbitration clause, and you'll find that in Article 37. Sorry, let me just get that. It's actually a bit earlier, and they do have provisions which relate to mediation, which they encourage, and then also to final arbitration. So they have got a provision in their arbitrations and ADR rules for ADR. And again, this is obviously not something where AFSA is referred to, but it's an indication that in every arbitration set up more recently, there is a provision for ADR. Now, what happens in the construction sphere is that almost all standard contracts have at least a two-step process. We've seen one which has got a three-step process, but it's DAB, dispute adjudication, and then arbitration. And there are two kinds of DABs. There's the ad hoc DAB, where you create a DAB once there's a dispute. Then you have a standing DAB. So, for example, when ETOLs were being constructed and implemented, there was a standard DAB which resolved disputes between the province on the one hand and Bombella Consortium on the other, and various other construction companies. So not Bombella. So there's a French construction company. And there, what we would do is a three-man panel. You would listen to the parties. You would indicate to them the likely outcome of the dispute, and then give them an opportunity to formally declare the dispute, go through a formal process, and get a formal award from the DAB. In about 80% of the time, there was no formal resolution of the dispute. It was informal because the parties had to work together, and they had a degree of confidence in the process. So the DAB is a halfway house because it can be very informal. It's supposed to be quick and informal. When the lawyers get involved, it's often not quick or informal, and as lawyers frequently do, they impose the kind of restrictions that we're more familiar with in our trial work, and that slows everything down. So DABs is an area where AFSA, as mediator, as provision of trained mediators, could get involved to persuade those who enter into these construction contracts along formal lines to interpose a mediation process before DAB, which is missing at the moment. If that is done, then I think a lot of the DABs may become unnecessary. I think there'll be a saving in costs, and where the mediator is allowed to give an indicative opinion, as we used to do in the standing DAB for e-tolls, it would be very helpful. So there you would go primarily to the large construction companies, and you would go to those who actually engage them, which would mostly be the state, Transnet, Sasol, Eskom, and the like. And that would be your space. So at the moment, all the standard contracts that I've seen, bar one, make no provision for mediation, and the one which does says simply it's not a requirement, but it is encouraged. So there needs to be, and these are international contracts. So these are not contracts which are developed in this country, but whenever a contract is concluded in South Africa between a construction company and the local employer, those standard agreements are amended in various ways. So it's very often you'll find that a number of clauses in the standard contract get varied by agreement between the parties. And so it's quite possible to introduce, by way of a variation, a mediation provision into those standard contracts. And as far as I can see, that's your way in. And again, it's for AFSA to approach the Transnets of this world, to approach the larger construction companies for a standard variation to the to NEC3 or FIDIC, which would include a mediation clause. And that's really that's the construction area, and that's where you get involved. And there is no penetration at the moment in that field. So it's wide open, and I think it would probably be fairly useful and welcome if the right people were approached, as in the case of arbitration.
Thank you, Chris. That was also just as insightful. And I think let me start us off at least on a question in the construction space. And from what I've heard, it seems that whilst not perfect, mediation as a tool has at least existed in construction to the extent that we now at least have a framework insofar as it's, been built or incorporated into these various contracts, and parties can then obviously, where there's a time delay or whatever the case may be, resort to those processes prior to approaching the courts. So at least from your experience, practically speaking, and it would be quite interesting for us to also get a sense of when it is that you become involved in a lot of these disputes that you ultimately run before the courts. What is mediation looking like practically insofar as, the resolution of construction disputes? Is it working? One might think that in circumstances of a project which still has, let's say, about an 8-month period, and perhaps we have a time lapse related dispute, it would be imperative for the parties to try and resolve that as quickly as possible. And I can't imagine, outside of going to, the court on an urgent basis, for any better framework then to do that under the confines of, mediation. Do you have any insight insofar as that's concerned, as well as, your involvement in mediation prior to it becoming litigious and, driving the matter all the way through the courts?
Yes, so when you look, let's start with DABs. So very often DABs, the members of the panel will be from the bar. And while those DABs are not regulated by AFSA rules, they involve, people like you and me. And then it's what happens before the DAB gets appointed that you've got to look at. And there, when you look at the correspondence between the parties, there's a lot of discussion about various disputes, and the disputes are often contractors wanting increased costs because of delays and the like. That space is unpopulated at the moment. So those disputes are really dealt with by the employer and the contractor themselves. Then the attorneys get involved, and there is no real attempt to resolve the dispute by professional mediation. There's an attempt by the parties, but because they're not really trained to do it, it often goes awry, and you'll find that the disputes persist because during the contract, there's some animosity built up between the contractor on the one hand, the employer on the other. The employer believes the contractor has delayed them. The contractor believes the employer's delayed. The employer believes that the contractor is just looking for more costs. So once it gets to the DAB, it's become fairly formalized. The positions are fixed. And there, I would imagine an approach to the attorneys who regularly deal with this. So let's say the Pinson Masons of this world, Berman, Gilfillan, Pinson Mason, who deal with this a lot. An approach to them to suggest to their clients that they engage in mediation through properly trained mediators before the dispute gets referred to a DAB would be quite useful, because they're the ones, it's those construction attorneys who are best placed to suggest to their clients that there be mediation.
All right. And that answer was quite helpful, and we in fact had a follow-on question which related similarly to that. Lesedi, your question, and I hope you've been answered. She had asked, in circumstances by way of example where, let's say you are a lay party and you don't necessarily know that mediation is an option. Lesedi asked, would it not be the first point of consideration for legal practitioners called to hear the matter at hand, to understand that before, we go immediately in the construction space to the DAB, let's try and mediate this between the parties in circumstances where, of course, the relationship is not broken down to the effect where that's impossible. And she also further asked, I hope it's a she, if not, how can that be readily considered as a tool? And I think you answered that question perfectly. It's the role of us, all of us sitting here, whether, you're about to enter into the legal field studying law, or you are an attorney, or, you work in the legal space, you're an advisor, or you're an advocate. It's our job to promote mediation in this space, because it is a tool which might be a little bit expensive to implement immediately. I mean, you'd need to have agreements which are reconfigured to at least include the possibility of mediation and subsequent arbitration if that's what's elected. But I think it takes us promoting it, and similarly to, your very interesting and an apt introduction insofar as Michael Cooper's role in setting up AFSA, that's pretty much exactly what he did. And that's the reason that AFSA is as big as it is today. All
Mm.
right, another question on the topic of construction, Chris. So Stephen, who I do know is a bit of a construction buff than most of us here, asks that taking the JBCC Principal Building Agreement Edition 6.2 2018, for example, into consideration, mediation is only a quote unquote may. So there's no imperative there instead of a shall. Should it not be up to the drafters of the JBCC and the other standard form contracts in the construction space to put mediation into the spotlight more often by requiring the parties to go through mediation first? So as a first step before you can even proceed to appear before any kind of DAB, how do you think that would be digested by the participants there too, particularly the mining houses, and how would that necessarily play out? What might that result look like?
I think, yes. So there are two ways of dealing with it. The one is to go to the drafters of those standard form contracts like JBC, go to them and say, we'd like you to introduce this. I don't know what their appetite is for it, but they may be quite happy. But the second is to go to those who use those contracts and say, even because it takes a long time to change one of those standard form contracts. I mean, if you look at the way NEC 3's been changed and FIDIC's been changed, it takes years before they make any amendment because they're standard. And so they've got to be very, very careful about what they change. So I would adopt a two-pronged approach. I would adopt the body responsible for the drafting of those standard form contracts. And in particular, for example, that where they say mediation is recommended, to say mediation is required. And then also approach the construction companies involved, the attorneys involved, and the major employers involved to include as their standard variation contract. Because these standard form contracts, NEC, FIDIC, they're never adopted without changes, to include in the standard variation of those contracts a mediation clause. So that's probably a dual approach. The one to the people who are responsible for the drafting of amendments to the standard form contracts, as well as going to the people who use the contracts to amend them in each case where they sign an NEC 3 or FIDIC or JBC.
That's quite interesting. And just to tag onto that, Chris, what do you think that apprehension or prohibition is insofar as amending those contracts, particularly in circumstances where perhaps a profession were to come together and say, look, there's a growing need for mediation. It's proved to be successful. We have established bodies that, take on persons with significant expertise that are able to either educate themselves or already have the requisite knowledge in order to mediate these things. What would then be the pushback insofar as not having to, sit for about 3 to 5 years, which is oftentimes, if not plus, oftentimes how you see these amendments ultimately, taking effect. How would we be able to really push that drive, which in essence would, support the construction space?
I think you do it the same way that it was done in respect of arbitration clauses. So AFSA needs to mount a serious campaign in which they persuade the role players to include mediation clauses into both the standard form contracts and the variation contracts. So say it's the change of the standard form contracts, it's not opposition, it's mostly just inertia, because there's a drafting committee. The drafting committee meet once every whatever, how many months, and maybe once a year, and it just takes forever. So if you read the notes to NEC 3, for example, or FIDIC, it'll show you the drafting committee and those things are like 30 people. So it's really inertia. And I think that if AFSA were to put as much effort now for the inclusion of mediation clauses as Michael Cooper did in respect of the inclusion of AFSA arbitration clauses, the issue will be solved. And then AFSA trained mediators will actually have that role instead of just the ad hoc. So at the moment, those mediators have ad hoc roles. So you get people who can't reach agreement, they're going to go to court, they're going to go to arbitration. Somebody says, why don't we try mediation? And then it says, oh, well, okay, let's try it. And then it works or it doesn't work. But there's no formal requirement. There's no standard requirement. And that's what AFSA's got to achieve in the long term.
And just playing devil's advocate, excuse the pun, do you think that's predominantly something for AFSA to achieve? What can the greater sort of legal fraternity be doing in support thereof, if anything? Of course, AFSA carries, you know, the name and the prestige, but is this not let's call it a combined effort that's required? All of us know about it, not just members of AFSA. So surely there should be, you know, a holistic drive towards this solve versus, you know, just simply running to court.
Yes, and I think that the members of AFSA, as opposed to AFSA itself, they will have relationships with firms of attorneys who do that work. So it's really sitting down with them saying, shouldn't you suggest to your clients on a regular basis, a systemic basis, as a first step, mediation? And then, you know, that will then gather momentum. So if enough attorneys who are in that field are persuaded that it's a good idea, you will get some momentum, hopefully, and then you'll see it in contracts. You'll see it beginning to emerge in your standard contracts.
Nice. You've given us all some homework to do. I guess it all sits on all of our shoulders. But Chris, that was very informative. We do have 2 more questions and I've left them until the end. So unless we have any more questions, I would ask for everyone to submit now. But these are sort of more general questions. And the first is from John. So John asks, what happens when one of the participants decides not to act in accordance with any decision which has been determined and is of course not in their favor? What are then the options in those circumstances? What compels any of the participants to act in accordance with, you know, a mediation decision? Of course, there are a little bit more, well, there are a couple more constraints when you get to sort of the DAB board and the process that follows out from there. But in circumstances where you've got a mediator which takes a decision, you know, can you go to court and apply for contempt? What are the avenues beyond that?
Yeah, so the first thing is that mediation doesn't result in decisions. It results in agreement or non-agreement, unless it's a MEDARB, which is a sort of a mixture between arbitration and mediation. But if the contract is properly drafted, where a party simply ignores a mediation clause, then if that's the party that wants to proceed to the DAB, they can't get there because it's a route that they've got to follow. The difficulty comes where the person who doesn't want to mediate is the defendant in that process, because then the claimant wants to. And then all that happens is that if he doesn't want to participate in mediation, mediation then comes to an end and the claimant goes directly to refer the dispute to a DAB, and then after that to arbitration. So the only consequence is that a claimant who just refuses to engage in mediation where mediation is required will be precluded from going further in the dispute resolution process.
All right. And last question, Chris, and I suppose the individual that asked this question says that they've been answered, but I thought it was quite interesting. I still want to run it past you. We obviously all know about Rule 41A. I don't think we can call it new anymore. We've sort of seen how that plays out or sometimes doesn't play out in practice. And when I say that, I mean in certain instances, we've both seen, mediation being taken up as an avenue, particularly in matters involving, large sums of money, where the facts are a little bit more intricate and the parties are perhaps more reticent to approach the courts out of fear of, being subject to the court's decision. How is it, in your view, that should Rule 41A be amended, if at all, to empower judges or justices to require the parties to mediate first, and not only that, but actually require parties to properly engage in mediation and not sort of write it off as a tick box exercise? Oftentimes, you receive a 41A and the parties simply say, nope, no mediation, not interested in it. Let's go take off we'll put on our gloves and go to court. Do you think that that rule needs amendment? And if so, how?
Look, I think I haven't looked at that rule in a while. As you say, usually what happens is somebody says, I don't think mediation is going to make any difference because we've already discussed this and the parties are too far apart. If there were a process where one of the parties said mediation was not appropriate, the other said, I want mediation and it is appropriate, then it's very much like those sort of case management meetings that you've got to explain yourself to the judge. So it's the fear of a judicial judicial approbation of what you're doing that would probably make it work better. At the moment, it just sails on. You don't go back to the judge. So if you have a look at the rule involving pre-trial meetings, where you don't deal with the topics that you're supposed to deal with, you don't get a court. You've got to say, I've done this, I've done that, I've done that. The problem is that if the defendant is the one creating the difficulty, then he didn't really want to go to court. So you've got to fashion a process which may be, for example, where a defendant fails to go to mediation and the court concludes at the end of the day that mediation may well have solved the problem because there is no real defense, there may be a special order for costs against the party refusing mediation. So things like that might help.
Interesting. And just one last question, and it's interrelated to, your answer. If the parties were to be forced to go to mediation, so by way of a guided process with steps where you appear before a judge in a case management meeting or something of the sorts, they would surely take mediation more seriously. And, that could potentially result in a lot more settlements or matters not being before the courts. And obviously the impact of that would be, we hear all the time about how bogged down our Johannesburg and Pretoria courts may be. Why is it that perhaps you think that hasn't been taken more seriously as an avenue by, the heads of our courts to really take this seriously and implement that in order to reduce the caseload that we see in our courts? I mean, waiting for a trial date for some 2 years at this point is sort of tenuous on a lot of people that choose to, go the legal route.
Well, I don't know the answer to that question. I think that the view might be that it would take up even more court resources to preside over mediation. So you've got pretrial conference certification. You'd have mediation as well. So they may just think it's just too much. And the answer may be that you should include mediation in your pretrial requirements that when you appear before the judge to get a date, and you have to persuade them that you've been through the pre-trial requirements and you ticked all of those boxes, that you've got to explain to the judge why mediation failed.
And, you know, it might be apt then because there's no prohibition for one to consider mediation at any point between, you know, the delivery of pleadings. And it certainly arguably should be something that must have been considered and substantively so prior to, you know, actually appearing before a court and litigating a matter. So that might be a suggestion that could work.
Yeah, so I think if you include it in your obligatory pre-trial requirements, it may make a difference.
Well, interestingly enough, there is that one requirement, and it's usually the first one, to the effect of, you know, have the parties engaged in settlement discussions. Is that the equivalent, or would you cast mediation as something slightly different and more involved?
I would imagine you need to be more specific, because the answer to that is yes, it didn't work. Whereas
pre-drafted.
Yeah, so mediation involves a third party. And so if you're going to construct a mediation requirement into that rule, you may have to, because it may not work in every case. It may be too onerous for small litigants to engage a third party. But what you might do is that as part of that, giving the judge control over the pre-arbitration process, is for the judge to direct mediation in a particular case because he thinks it warrants that effort. And then it would be mediation either by agreement between in front of somebody, or the court directs mediation in front of X, which would be a member, you know, say, for example, a member of AFSA. Doesn't have to be.
All right, interesting. Well, a lot of food for thought. Thank you very much for your time today, Chris. I know you have a extremely busy schedule, so we do appreciate you taking out the time to hold the session with us. And if I might just remind the rest of the participants which are still on the line, I think earlier I'd said our next session was on the 2nd of September, bad me. It's actually on the 3rd at 5 o'clock, and the topic is Mastering Mediation from the Ground Up, Mediation in Action, and that should be just as interesting as the balance of these sessions. We also want to thank all of you for taking the time out to attend this, and thank you for the questions, and we hope to see you again next week, Tuesday afternoon.
Thank you very much. Thank you, Neddy.
Thanks, Chris. Have a good evening, everyone. Thank you.
Bye.